Hello everyone, this is Jackie Jones, and this is the last lecture series of lectures that I'll be recording for legal and professional skills over summer. This series of lectures is on best practice and what that actually entails. The first module, we're going to actually be thinking about what is the legal culture and what, if any, barriers exist to justice for the community. So by now you've nearly completed legal and professional skills, and it's given you an opportunity to reflect on what it means to actually be admitted, completing the PLT program, becoming an Australian lawyer. What does being part of the legal profession mean, and what is the legal culture, if any, that we need to consider? Slide 4 has a definition of culture, which I think is quite an interesting one. And if you go to slide 5, you'll have a look at the varying components that academics identify as relating to legal culture. But in addition to those, you might readily think are appropriate as part of the component of legal culture, there's some other things that we as lawyers are used to, such as just how we speak about one another. In a court setting, we talk about my friend, we have modes of addressing various judicial officers and each other. Even our language is very different to the man in the street, what they might be referred to as how we identify people in court process, how we identify them in transactional matters, mortgagee, mortgagor, all different ways that we actually use legal words. We also have dress codes, and that's something that you need to bear in mind when you do go into practice as to the appropriateness or otherwise of dressing. Bit of a tip that I always stated was that even if it was a day that I didn't think I was going to go to court, I always had a jacket with me, just in case I had to rush to court for a mention of some type. There is changes to culture, and that's happening over the years, and it has impacts by a number of things. First of all, just a gender impact. The increase in females in the legal profession is certainly quite a change. Globalisation and the ease of communication globally is another aspect as to how we have, as a profession, changed, having incorporated associations, for example, and legal practices. So there are a number of challenges as part of the profession and the community generally, and one of those challenges is in fact the access to justice. And I'm sure that through your law school readings and your learning, you'll be aware of the difficulties some people have to accessing justice. And of course, if we look at slide 9, a number of the barriers are identified in those snapshots of ignorance, knowing that there is in fact relief available. Cost is a huge one, as well as just discrimination and disadvantaged. And of course, the old adage of ignorance of the law is no excuse, but many people still do have difficulty in knowing their legal rights. Very, very challenging to know, well, where do I stand, particularly if it's against a multinational, if it's someone in a far more superior bargaining position to you. Apart from the cost, and we do have an understanding of legal fees being prohibitive to many, and the limitation of legal aid to others in the community, it is a barrier, and that has seen an influx in self-representation through the court process. There are many disadvantaged people in our community as well, and they have their own particular barrier to being acquainted with their rights and being able to explore those rights in a legal setting. The slide on costs is an interesting one because it is a barrier, but how can that be overcome, or what can be impacted on to change that as one of the barriers? Some lawyers enter into cost agreements, And there is a trend towards litigation lending, for example, where insurance companies, it's really like an insurance policy, where they foot the cost of the legal fees, but of course, in return, they get an interest paid on the money and it comes out of the ultimate settlement. People with mental illness or an intellectual disability often are the ones that we identify as having been discriminated about and having a sort of a limitation to justice. But I want you just to think about a person's physical disability and how that can be a challenge to many. Even just getting around the city or coming into a solicitor's office, for example, whether it's in suburban practice or wherever, can be very difficult to people with challenges from a physical perspective. There was a report in 2006 by the New South Wales Law and Justice Foundation, and that looked at not only personal barriers but systemic barriers to people facing accessing justice, and those were looking at with people with mental illness and how that they could be in some ways have a better way of getting into the system by acknowledging the challenges that they have. So are there any solutions to those barriers that we have identified? And you'll see there that there are a number of identified solutions, and we'll just touch base with a couple of those. Legal aid, of course, is one that you are very familiar with. The challenge with legal aid is always funding, and they have not only a means test but also an eligibility from a when I say means, financial means, but also is the case one where there is a need for it. So it's means and needs, and so a lot of people do miss out on legal aid funding, and it is very tight. Now, if people are ineligible for legal aid, there's not a lot of choices available. Some people do choose the self-represented route. Others may be fortunate enough to have a lawyer that will do work on a pro bono basis, or they may beg, borrow and steal to pay the lawyer either at their designated hourly rate or maybe come to an agreement on a reduced rate. Community legal centres have been a fantastic way of enabling people to have access to justice, particularly those that we identified have difficulties with barriers to the legal process. Pro bono is another area where a number of law firms particularly think it is essential to provide some pro bono services, and you'd be surprised how often that occurs. You might just think of it as running a litigation matter for somebody, but in fact a lot of firms and solicitors, in fact I know myself, will do free pro bono work in a form that may not be readily identifiable. It might be doing work on a discounted rate or for no charge at all, such as a will if you've done a transactional matter, or you may have done a family law matter, or you might be spending time in conference with a client and takes 2 hours, but you might charge them for 1 hour. So that in some ways it is a pro bono way of giving them a benefit, a legal benefit and legal access to justice at a way that benefits them. Some barristers do take briefs without a fee, and an amicus curiae is a friend of the court, and this is where a self-represented person and they might ask by the court to assist with an amicus curiae with a practitioner who might be sitting in the courtroom and just be able to guide the person and assist the court in that realm. Self-representation is certainly not new, and one of the things I'd want to stress to all of you listening to this is the New South Wales Law Society guidelines on dealing with self-represented litigants. I certainly think that they are going to be growing, and it's not just the family court where people are exposed to self-representation. as I said, legal fees are expensive, and we need to be mindful that people will come and act on their own behalf. They have every right to do that. It does impact on how matters proceed, and it certainly can make negotiating with a self-represented party very challenging. But please have a look at those guidelines, because if nothing else, we as a profession need to remain professional in our dealings with self-represented litigants. Now, just one of the other ways that can assist people in accessing justice is through dispute resolution processes. And of course, community justice centres have been a wonderful way of enabling people to resolve issues through confidential mediation. And there's also, for example, now compulsory mediation in some avenues, such as parenting matters after the breakdown of a relationship. There are tribunals with simplified rules of procedure, and that people are encouraged to appear without lawyers. So again, this is a way that enables people to have access to justice. Finally, plain language. The way we communicate, what we say to people, whether they're self-represented litigants or whether they're our own client, we need to bear this in mind as part of understanding that the legal culture, whilst familiar to us, isn't necessarily familiar to everybody else in the community. And it can in itself be a barrier to people understanding what their legal problem is and finding a solution to their legal problem. So we need to assist them in doing that, and we need to not only speak but write in a way that is clear and concise, so that the clientele and the general public do have an appreciation of what are the avenues available to them for their particular problem. And that's the end of this module for this lecture. Thank you.